5 seconds to go. Start. The intent of orders 33 and 44 is unmistakable. They exemplify the cherished principle that lack of monetary capability does not preclude a person from knocking on the doors of the court to seek vindication of his rights. It is unquestioned that a person dissatisfied with the amount of compensation received can file an appeal. In the present case, for a claim of rupees 10 lakhs, the tribunal awarded compensation which was less than rupees 2.5 lakhs. Without commenting on the merits of the matter, we recognize the desire of the claimant appellant to file an appeal. Once again, turning to Darshana Devi Supra, we refer to certain observations made therein. The right of effective access to justice has emerged with the new social rights. Indeed, it is of paramount importance among these new rights since clearly the enjoyment of traditional as well as new social rights presupposes mechanisms for their effective protection. Such protection, moreover, is best assured by a workable remedy within the framework of the judicial system. Effective access to justice can thus be seen as the most basic requirement, the most basic human right of a system which purports to guarantee legal right. We should expand the jurisprudence of access to justice as an integral part of social justice and examine the constitutionalism of court fee levy as a facet of human rights highlighted in our nation's constitution. If the state itself should travesty this basic principle in the teeth of Articles 14 and 39A, where an indigent widow is involved, a second look at its policy is overdue. The court must give the benefit of doubt against levy of a price to enter the temple of justice until one day the whole issue of the validity of profit making through sale of civil justice disguised as court fee is fully reviewed by this court. In the present case, although the state is not the one in appeal, the observations in regard to the insistence upon court fees by the High Court to be taken from the meagre amount awarded as compensation, even after having recorded that she had not yet received the said amount, has prompted us to refer to the above extract. The ground upon which the claimant appellant's application to file the appeal as an indigent person was rejected was that she had received compensation by way of the award of the tribunal and therefore she was not indigent. We find this observation to be belied by the impugned order itself, as the learned single judge has recorded the submission of the counsel for the claimant appellant that no money stood paid to her at that point in time. So, even though she had been awarded a sum, her indigency was not extinguished thereby. Any which way, in our considered view, the High Court was incorrect in rejecting the miscellaneous application. There is a further ground on which we find that the High Court erred in not allowing the claimant appellant to file the appeal. The language used in orders 33 and 44 so far as deferring of payment of court fees is concerned, as was observed in Khadar International Supra, that if the suit so filed as an indigent person succeeds, the court fee shall be deductible from the amount received as a result thereof, as if the person who files the suit is not an indigent stock.